Court now proceeds to the third case on today's docket, Shim versus Buechel. Forgive me if I mispronounced it.
Good morning, Your Honors. May it please the Court, John Bogdanoff for the petitioners. This is an appeal involving proceeding supplementary, but actually the issues are pretty interesting as they involve issues of sovereignty and separation of powers. The conflict issue between the 5th DCA decision in this case and the 4th DCA decision in Sargent relates to whether a Florida trial court has jurisdiction in proceeding supplementary pursuant to Section 5625 over assets or an asset located in a foreign country. The trial court, relying in part on the Sargent decision out of the 4th DCA, held that it lacked subject matter jurisdiction under 57.29 over the asset located in Korea. The 5th DCA disagreed, held that a Florida court has in personam jurisdiction and authority under 5629 to compel the petitioner, Shim, to turn over the foreign asset to the Florida court in the proceeding supplementary.
Counsel, I'm sorry to interrupt you. What is the asset at issue? Is it the check or is it funds on account at Woori Bank?
Well, according to the order of the trial court, it's essentially both. It's the check on representing funds on account in the South Korean bank.
Okay, so then my question about that is, if one of the assets is funds in a Korean financial institution, do you agree that something must be done to domesticate that judgment in Korea and seize those assets somehow? What, if anything, has been done to give effect to this judgment in the courts of that country?
To my knowledge, nothing. We believe the 5th DCA decision is erroneous on both counts, that the trial court had neither subject matter jurisdiction nor in personam jurisdiction which would extend to this asset located in South Korea. Under Florida decisional law, in personam jurisdiction over the petitioner Shim does not extend to adjudicating issues of the right to possession and title to an asset located in a foreign country. The decisions relied on by the 5th DCA holding that the trial court had in personam jurisdiction which would extend to requiring and compelling the petitioner to bring this asset from South Korea into the Florida court are inapplicable because they basically fall into two different camps.
Counsel, are you familiar with the decision of the Supreme Court in Fall?
Yes.
Okay. What do you say to where the Supreme Court in Fall said that a court's personal jurisdiction over a defendant gives and I quote here, power to require a defendant to do or to refrain from doing anything beyond the limits of its territorial jurisdiction which it might have required to be done or omitted within the limits of such territory?
Well, the way that decision has been applied in Florida has been two different contexts. One is where a real property situation where the court has authority to impose a certain remedy over property located in a foreign jurisdiction. This case, as well as the Hershert case, relied on Fall in saying that in that context where property is located in a foreign jurisdiction, the trial court having in personam jurisdiction can impose certain remedies relating to that property. For instance, a constructive trust was the Hershert case. The other case, Siunga, which also relied on that concept, was a case where the court said, well, a personal representative can issue a deed relating to property located in Romania. The court cannot directly affect title to that property.
But I'm struggling to see the material difference between that and what we have here.
Well, I think in this case, it's the seizure of an asset located in a foreign country and the requirement that that asset be brought from that foreign country into the Florida court. That's different than those cases that have applied the Fall concept and language that you've referenced, which involve imposing certain remedies on property located in a foreign country, not requiring that, anything to be brought back to this country, but imposing certain remedies that indirectly may affect the property. Here, we're talking about a direct effect. Direct title to this asset located in Korea is under the request by the respondents. They say we want ownership of that asset, and you need to, petitioner, you need to bring that asset back from South Korea into the Florida court, and we own it. Well, that's directly affecting the title, and the cases don't go that far. They don't say that you can directly affect the title. They say indirectly affect the title, and so we think this request here is far different.
But I understand it's an indirect effect on the property, but the court is acting on the person. And to the extent that the person has control of the property, it seems like to me that the action on the person would be viewed as having an indirect act within this framework on the property, and just like it would in these other cases you're talking about.
Well, but in this case, it's a direct effect on the title to the property, on the ownership of the property. According to what the respondents request, they sought an order to turn over the $4 million to the respondents. There's nothing, they want title to this property. So this seems to go far beyond the concept that you can indirectly affect property. This is a direct requirement that the property, under their theory, that the property can be brought from another sovereign nation into the courts of Florida.
But isn't the critical point that any remedy for noncompliance would just be directed to the individual, any punishment or whatever? It wouldn't, there's no one saying that the court could directly do anything to the property. So, I mean, that's what it isn't.
The court's
that,
not sending the sheriff to South Korea, right? I mean, we all agree on that.
Well,
the sheriff probably wouldn't go anyway.
In this case, conceivably, it wasn't requested, but conceivably, there could be the possibility that the court is asked to maybe freeze an asset or enjoin that asset from being removed. But that wasn't the request. The request here was, we want that asset brought into the state of Florida. And so that's a direct action on that asset. That's not an indirect action, an indirect action may be freezing an asset or enjoining a certain effort to transfer that asset. Those would be more indirect. Those weren't requested here. Those aren't the issue in this case. This is, we want that asset and we want you to compel the petitioner to bring that asset back into Florida.
So if I hear you right, you're conceding that, who knows what date this check was drawn. Let's say the funds are no longer in the account. So the check is tendered to the state of Florida, but it's worthless because the funds have left the station. Our holding that being within our, sort of jurisdiction and our being able to exercise that jurisdiction, commanding the individual to tender the asset, that is the check, would not give us the same jurisdiction to seize and freeze assets. You're not arguing that, are you? We could then unscramble the egg and somehow compel Woori Bank to put the funds back in the account.
Well, I don't think there can, under the in personam jurisdiction theory, that any of that can be done, because that would require direct effect on the check, on the assets in the account, and that goes beyond the in personam jurisdiction, and now it's impacting the sovereignty of another nation. I would say that goes beyond what the settled law is. The other series of cases involve where there's a possessory interest. The GE case and the Shank case both involve situations where there was an asset in Florida. Shank was a stock certificates. General Electric was an aircraft, a jet. Both of those situations, there was a statutory lien or a statutory certificated interest in the asset. That asset was then taken out of the state of Florida. The jet was removed. The stock certificates were removed to Canada. And the courts held that in those cases, that the Florida court did have the ability to affect those assets.
Well, those do seem somewhat distinguishable, don't they, in that a stock certificate is, or a bearer bond, for example, is an asset on its face, and an aircraft is a chattel, right? So I think all of reading chapter 56 together, levying on those things makes sense because they are, in and of themselves, an asset. Check's different. A check is nothing more than a promise to disburse to the order of someone certain funds. It doesn't create a lien, right? Like if I write 2 checks at the same time and they're both for the same amount and I only have enough to satisfy one, the first person who gets to the bank wins. The person with the other check doesn't have a lien, can't say, oh, hey, by the way, I also have this asset. So it would seem to me like those cases are distinguishable. Don't you agree?
Well, I do think those cases are distinguishable if for no other reason than they do involve possessory interests that already exist in the state of Florida on behalf of the litigants. And in that case, the state of Florida is vindicating the possessory interest that was created in the state of Florida, and the asset was then removed. And Florida is vindicating that statutory or lien interest that they have created. That's not our case. Our case is totally different.
Counsel, could I have you kind of switch just briefly and address the statute, 56.29 subsection 6, and why you think that does not give the trial court the right to enter this type of order?
Well, nothing in the statute talks about extraterritorial effect. The 4th District in the Sargent case refused to expand the statute beyond effect into a foreign asset.
But they admittedly said that was a policy decision. There was nothing that they could actually read in the statute about that.
Well, they were pointed to a New York case which involved a similar statute, and the New York court had read the statute expansively and said, well, there's nothing indicating that it doesn't preclude extraterritorial effect, so we're going to determine that as a judicial matter that the statute has such effect. Florida has a totally different approach. We've cited cases in our briefs that in Florida, a statute, in order to have extraterritorial effect, that's a legislative decision. And if the legislature determines that extraterritorial effect of a statute is warranted, they have to provide that in the statute. There has to be a clear intent from the legislature of extraterritorial effect. This statute, 5629, contains no such clear directive. It says nothing about extraterritorial effect. And so, as a result, the legislature has not given it that type of effect. So if the legislature did want to have extraterritorial effect, Sargent was decided in 2014. They've had 6, 7, 8 years. The legislature could have gone back and said, well, the Sargent court refused to give it extraterritorial effect. We want 5629 to have extraterritorial effect. We need to amend it to provide that. They haven't done that. So
the statute, 5629 says the court may order any property of the judgment debtor not to be levied upon and applied toward the satisfaction of the judgment the judgment debt. The court may enter any orders, judgments, or writs required to carry out the purpose of this section. And that's pretty specific.
Well,
once I have jurisdiction over you, and then I order you to obtain and make these things available.
The case law we cited indicates that just using the word any is not enough to provide extraterritorial effect. If the legislature intended it, they needed to be specific. Using words like any doesn't satisfy the requirement. There has to be a specific provision saying that this statute have extraterritorial effect.
Where is that in our law, in Florida's law? Is there any statutory provision you can direct us to that creates a blanket presumption against extraterritoriality unless specifically invoked by the legislature?
Not that I'm aware of. I do know that there's ample decisional law. The equitable life case that goes back to 1911, as well as other cases that we cited in our brief, stand for that proposition that if statute is going to have extraterritorial effect, it's for the legislature to make that determination. And like I said, in this case, the legislature has had every opportunity to make that determination. They have not done so. So we think the Sargent case was correct in refusing to read the statute broadly like the New York court did, rejecting that concept, and not judicially expanding the statute to provide for extraterritorial effect, and to leave that issue up to the legislature as Florida law suggests.
Counsel, you are now into your rebuttal time. You may keep going, but you are consuming your time.
I'll save my last 4 minutes and 40 seconds. Thank you very much.
May it please the court, Edmund Kester for the respondents. I'd like to begin with section 56.29, and there is under subsection 6 a part where it says the court may enter any orders, judgments, or writs required to carry out the purpose of this section, including those orders necessary or proper to subject property or property rights of any judgment debtor to execution. I submit to the court that 56.29 subpart 6 and the whole section is not only broad, but is also specific. It actually says the court can enter orders requiring property to be subject to execution. What brings us here today is basically a bearer instrument. The testimony is it's a cashier's check, a negotiable instrument in a safe in somebody's home in South Korea. The court has undisputed personal jurisdiction over the debtor. We ask the court to require the debtor to bring the bearer instrument, the negotiable instrument, to the state of Florida so it can be executed on. There is no effort whatsoever to have the court send a sheriff over, some kind of in rem jurisdiction, to go take the property. It's simple. The debtor brings the check over to Florida, and then we execute on the check.
Okay. Does it require any endorsements?
The court, it may require endorsements. We don't have a copy of the instrument. So if they bring the instrument over, they show it to the court in the proceeding supplementary. If it requires endorsement and it's not truly a bearer instrument, it's not truly a cashier's check made payable to anybody, the court, like it can require somebody to sign a deed, it could require him to endorse the check.
Okay. And the same question I asked your colleagues. What if the funds represented by the instrument, you're characterizing it as a bearer instrument, are no longer on account at Woori Bank? Play that out for me.
Garden variety contempt issues. Courts all the time, when they want to put somebody in civil contempt, especially if it's not to pay a debt, do they have the ability to pay? If they do have the ability to pay and they say you have to pay, in this case, do you have the bearer instrument, the cashier's check? He says yes. They say send it over here. If he then goes to the bank, closes the account, moves the money to Japan or Hawaii or somewhere else, the court has contempt powers again and can say, we entered a final judgment against you, we had a proceeding supplementary, we had you testify, we had your deposition testimony, we know you had the money, you admitted you had the money, and now you moved it again to circumvent the court. The court at that point could consider contempt, which is specifically permitted under 56.29, and could consider incarceration, with the purge condition being actually give us the money this time. Okay. Nobody is saying to go over to a bank in South Korea, judge, and somehow attach it.
So again, I'll ask the same question I asked your colleagues. What steps, if any, have been taken to do what you would do in a garden variety judgment enforcement case abroad and domesticate the judgment in the country where the asset is and attempt to enforce there? Has anything been done in this case to do that?
We have very good counsel over there. There's litigation over there where they're trying to relitigate all these same issues in South Korea. The next hearing is set for March 24th. We won at the trial court level. I went over to South Korea myself. It's up on appeal now, and March 24th, we believe, will be the final hearing. We also are seeking domestication over there as well. It does raise the point, though, that the idea of proceeding supplementary in personam jurisdiction is to hold the debtor accountable. Otherwise, you could just bounce the money around the states, bounce the money around the world, bounce the money around the country. If you found a country that didn't allow domestication of judgments, you could just put the money over there. Even if you were a plaintiff in Florida, even if you lost in Florida, even if there was a judgment against you, you could just jump it around. So in the Sargent case, where there's discussion regarding this could affect the need to domesticate judgments, it sort of misses the point. You may domesticate a judgment if you need to. You may no longer have personal jurisdiction over the defendant because he may be gone and you can't get him back in court or something like that. There could be real property. You want to domesticate a judgment, get yourself in line in the lien. You want to foreclose that property in another jurisdiction. The domestication process doesn't go away. It's clear from the case law there is a very big difference between in rem and in personam. And we're here only on the in personam. We are not here in any kind of prejudgment writ of attachment. We're not here in some territorial case where the state of Florida is trying to seize fish that were caught outside its territorial boundaries. We're not here in any of those contexts. And I would suggest, too, that the GE case cited by the 4th District Court of Appeal as being different because there was a fuel lien. When you look at that case, the court was actually very clear. They were only going under in personam jurisdiction. The lien hadn't really been perfected. There wasn't anything tying the jet to Florida. They said GE has the minimum contacts. We have personal jurisdiction over GE. Bring the plane back so these people can try and execute on it and enforce their lien. The court didn't say, we have a lien, send the attorney general or send the sheriff of Dade County and have them go find that plane and bring it back. They said to Boeing, they said to GE, bring the plane back.
Are there any kind of restrictions? Like what if he had taken the money and bought a fleet of vehicles? Is he required then to put 20 automobiles on a ship and have it shipped from South Korea?
Super interesting. I thought of that last night because apparently he has a nice Porsche over there. There is some discretion from the trial court as to what the trial court does. So if you say the fleet of trucks or something like that, if we were to come in and say, Your Honor, we want you to force this debtor to bring this fleet of trucks over, and the debtor said, hey, wait a minute, there's liens in that other jurisdiction, I don't own them all, the transportation costs would outweigh the value of the trucks, this would be overly prohibitive, I can't do it. That's the garden variety trial court evaluating what we're doing. And he has other assets over there. We went for the negotiable instrument that he said was a cashier's check in his safe because it was particularly insulting to the creditor and the court to say, I have the money and I'm not going to give it to you. If we literally looked at his Porsche and said, okay, how much does he owe on it? What's it really worth? Are we really going to try to ship it? Are there any dealership laws or car laws that we're going to have to deal with trying to bring in a foreign car into America? And the court has discretion and the parties have discretion. It would be an asset by asset analysis, both by the creditor and by the court, and it would be up to also what the debtor has to say. And there also has to be an ability to comply. So if you're going to require somebody to do something using in personam jurisdiction and they're not able to comply, they would do that. In the GE case, if
so
they were
your position is any personal property is game, subject to whatever discretion the trial judge has on whether it makes sense or not.
Well, and whether the debtor would have the ability to comply. And the example I was just about to give is, let's say GE said, the plane's broken, it's been shut down by the FAA, we don't have our quarterly services, we have no way to get it to Miami, we can't bring it to you. If they were then to hold GE in contempt, and it were up here on this court as to whether you could hold somebody in contempt that doesn't have the ability to purge, I think the clear ruling would be there had to be a factual finding that they could comply. But yes, proceeding supplementary would let you get at any personal property anywhere in the world if the debtor had the ability to comply, it made sense, and it could be done.
And because you're proceeding totally on this in personam theory, this whole issue about the extraterritorial application of the statute is just a total distraction because
it's a
you're
statute
to the purpose of not extending its reach abroad.
Correct. And we would be back to contempt issues. So if they canceled the bank account at the bank, So when the bearer instrument was presented, it didn't clear because the bank account didn't exist anymore, assuming the bank let them do it. And they moved the money around. We'd be back at another evidentiary hearing saying, Judge, here's the dishonored cashier's check. It came back as account closed. We wouldn't say, Your Honor, let's go after the South Korean bank. It would be, bring the debtor back in, let's get him under oath. What did he do with the money this time? And then where is it now, and can we prove what he did with it? And that would be exactly how the case would proceed. And it wouldn't be unduly burdensome at all on the judiciary. We see this happen in all of the other cases. Ex-husband takes the stock and puts it over in Canada, and they have to cancel the stock and have it reissued to get it back. It doesn't have anything to do with whether you have a security interest in stock or anything like that. The stock was removed. They didn't send a sheriff over to Canada to bring it back. They made the debtor do it. Same thing on all these other cases. You know, that's the way it is. In the Second District Court of Appeal, in the Dusaya case, a Texas court said that a wife had to sign over a deed to Naples property in Naples, Florida. Refused to do it. Court had the right to enforce it. They said, by the way, we're going to ignore the in rem portion of the Texas divorce judgment that said he now owns it. And we're going to ignore that. We're not going to give it full faith and credit, but we're going to enforce and give full faith credit to the in personam part of the judgment, which is she has to execute the deed. The Sewinga case, telling the personal representative he's got a deed property over in Romania, the First District Court of Appeal said, we're not saying what proper title is over in Romania. We're not going over there and messing with their affairs. We're saying we're a probate court. We have jurisdiction over a personal representative, and they have to do it. The Fifth District Court of Appeal in Hershey, when the California court said I'm imposing constructive trust on property in Florida, the court enforced it, again, in personam. It said remand for everybody to address the homestead issues. Is there a homestead protection if you've taken money out of a trust and bought a Florida homestead with it? The appellate court said, I'm not dealing with that. It's ripe now. Go back and take a look at it, trial court. But that's what all of these cases say. The Sargent case is an outlier. And if the Sargent case were allowed to be good law, and if the argument by my esteemed counsel were that courts have to have territorial, they've got to find something in a statute that discusses territorial, imagine coming back here on anything else, on a discovery matter. Somebody says, well, I've taken all the documents and hard drives and I put them in Alabama. So, Your Honor, I don't have to produce them in my discovery in Florida because there's nothing in 1.350 that says it's extraterritorial. And the court would say, what are you talking about? You're the plaintiff in a case. It's relevant discovery. I've told you to give it to me, and I'm going to hold you contempt if you don't. It's, no. It's extraterritorial. I had it moved to Alabama. And by the way, if you get some kind of order and you domesticate it in Alabama, I'm moving it to Georgia next time, and we're going to play the 50-state game. It would have broad implications to suggest that a court would not have the ability to exercise in personam jurisdiction, require people to respect the court, and follow the court's orders. I could continue to talk if any of the justices have more questions, I'm happy to answer. Otherwise, nothing further. Thank you.
Just briefly, in the Burns versus Rosen case, that was a first DCA case, the court did address using terms such as any and all in a statute as to whether that's sufficient to provide for extraterritorial application, and they rejected that concept. They said extraterritorial effect is not to be given by implication.
How do you respond to counsel's argument that all of that is sort of a red herring because they're not proceeding in rem? They're not trying to get the funds, on deposit. They're trying to command this individual to comply or face contempt. How do you answer that?
Well, they are seeking the funds. They want them brought into the state of Florida. So they're not
Perhaps, but not in this action. Your opponent has said that they are proceeding in this action solely in personam, and that the remedy they are seeking is a command for an individual to behave a certain way. They are not, in this action at least, seeking any kind of in rem relief. Doesn't that moot the whole discussion about extraterritorial effect? And if not, why not?
No, it doesn't, because first of all, this was an action under 5625. So in order to give extraterritorial effect, the statute has to provide that. As for the in rem issue, the in personam issue, We pointed out the cases are distinguishable that the opposing counsel relies on, as well as the 5th DCA relies on. In this case, there was no asset that was in Florida that that the petitioner removed to another state. This is a situation where this asset is in Korea. He hasn't taken an asset like the jet that for unpaid fuel bills had a lien slapped on it and then was removed from the state of Florida after that happened. Or the case with the ex-husband who took the stock certificates that had been issued in Florida, took them and brought them to Canada, and then the Florida court says, "Nuh-uh-uh, that's not going to cut it." Notice in that that's the Shank case. The court didn't say bring the stock certificates back even. What the court said is, you need to reissue new stock certificates and give it to the opposing side. So even in that case, the court didn't say bring those stock certificates back. This case does not involve taking assets. It doesn't involve taking discovery material and moving it out of the state. This is an asset that's been in Korea. There's no indication whatsoever that this asset was here in Florida and then has been removed.
It seems like that distinction would only matter in in-rem cases, not when we have a personal jurisdiction type case.
Well, the personal jurisdiction still has to be consistent with due process. And if this asset was never in Florida, there's no connection. If we're going to talk about due process and in rem, there's no connection with this asset to the state of Florida. So to say that the state of Florida, the court,
But why does that matter?
because in personam jurisdiction is the concept is basically has to comport with due process, and any
Over the person, not the property, though, right?
Well, but in this case, it's the person whose asset is a Korean asset, just as if these were stock certificates in Korea that had in a Korean corporation that had never been in the United States, have never been, in the state of Florida.
So, counsel, I want to make sure I'm clarifying what you're saying. Let's say judgment was entered for $100,000 against someone, and their money was all in an Alabama bank. That's right next door. Is it your position that under oath they said, yes, I have $100,000 in an Alabama bank, or let's say it's a cashier's check in Alabama, and would the court in that case, or is it your position they would not be able to say, you need to bring that to Florida and pay?
Under in personam, if
Yes,
they had in personam
they
jurisdiction?
have that jurisdiction.
I would say no. I would say the remedy is, as opposing counsel indicated, they're seeking to domesticate and obtain this asset by going to Korea, and apparently they've got some action in the works, and that's what they're attempting to do.
But that's not exclusive of also seeking in personam relief, is it? Like, those two things can't be mutually exclusive, or else you're in the box that he's talking about with the discovery materials. Any chattel that you'd move at any point, would you just sort of play whack-a-mole? That can't be the law.
Right, but there's no indication, in this case, that there's any movement of this asset. And furthermore, as I said before, this asset was never in the state of Florida. So we're talking about an asset that is a uniquely South Korean asset. And, trying to use in personam jurisdiction to reach that asset, we think creates real issues of sovereignty, and that's...
So if it had been here and he moved it to South Korea, then it would be okay to get it?
I think that might be a different case. I think that in that case, an argument might be able to be made that there's at least there was some action in the state of Florida. Even so, the cases that we've cited and discussed don't go that far and say that you can go into the foreign country and require the defendant to take that asset and bring it back. They don't seem to go that far. So. Thank you very much. Appreciate your time and interest.
We thank you both for your arguments in this case. The final case on today's docket will be conducted remotely at 11:30. So the court will now stand in recess until we reconvene remotely at 11:30.
All right.